I'm going to move on to best interests of the child. And again, you know this list of front. You can do it off by your heads, right? Go. No, it's kidding. Emotional well-being, views of child, history of child care, stability, impact of family violence, ability to exercise their parental responsibilities. So I found a couple of cases this year that kind of were interesting because sometimes I find that judges give a little bit cursory, analysis around these topics. So anytime I see something, it's like, oh, that's interesting that you put that in there. I kind of like flag them. So these aren't cases because they are anything earth-shattering. It's just like, oh, I haven't seen the court talk about it this way. So that's kind of neat. And what you have to do when you're supporting your clients is certainly think outside the box. Like anything you can fit into emotional health and well-being, put it in. Like family violence, as we know, has just grown in terms of what is the scope of family violence, right? So be creative. And there's always the other categories of things that, like this is not an exhaustive list, right? So this is a list that's like, if you think of anything you think, this is about the best interest, this is about the child, put it in, right? So anyway, this is why I picked a couple of these cases, because I thought, oh, this is kind of interesting. So the first one is small, sorry about the print, CTM and TJM, is Mr. Justice Verhoeven. And under the child's health and emotional well-being, the mom had, it seems to me more the judge had raised the fact that in looking at the father's bank records, it was clear the father was eating out a lot at fast food restaurants. Like, at one point he looked at bank records and was like, that's 30 fast food restaurants. So he was concerned, obviously, about, well, if you're eating that much fast food restaurants, you kind of don't look that healthy. What are you feeding the child, right? What's going on for this child? And so Mr. Justice Verhoeven was concerned that this habit might affect the child. Now, there was a Section 211 report, and it wasn't raised by Dr. Elterman, and it didn't appear actually that the mom even raised this issue of the feeding of the child. And I don't know, I have clients who do raise this issue about what foods are given to a child. Certainly things, if you think about other things like the use of screen time is a huge one, right? Screen time is a big one. So think about that. That can go in health and emotional well-being, can't it? So if you have these clients who have, yes, that's a real concern to me, and it's a legitimate concern. Child playing like Fortnite at age 5, probably not okay, right? Or watching that movie Joker, bad, right? So you can maybe put that in emotional health and well-being, emotional well-being, right? In the end, the judge didn't put a lot of weight on the matter, but just wanted to flag it as a concern for the parties and possibly for future decision makers. So it seemed that Mr. Justice Verhoeven himself picked up on that and said, hey, maybe you should think about this, and as a signal. Okay, so that's one that's new. An interesting thing where Mr. Justice Verhoeven also interviewed the child. The child had said she wanted to spend more time with the father and less time with the mother. And the judge thought, it might be because he lives on a farm and he has animals, and she likes animals. But when he talked to her, she didn't seem to make any preference one way or another. The difference in the difficulty in this case, the parties lived in different places, so there had to be a parenting regime that reflected that. One issue under the ability to exercise responsibilities, and when I read this, I thought, oh yeah, this makes sense, but I hadn't actually, I think, seen one that had put this in there. So the mother, unfortunately, had a history of using drugs, and she'd been doing way better, but in the past, of course, because of that, she had shown some poor judgment. And the judge, though, recognized that the mother's judgment might have been impaired by factors beyond her control, such as addiction and mental health issues. So he wasn't sitting there trying to assign fault to her, but he did find that, given that the father was more likely to exercise good judgment than the mom was, right? So as you know, the factors are kind of like, they try to go, one for mom, one for dad, or figure out who sort of is better on a particular category. All factors considered, they're even, like stability, they're even, so forth. And so in this factor, the judge gave the dad a bit of a leg up on this one. This one was an interesting one, and this one is the arrangements that would require the guardians to cooperate. And this is often a big one that, either judges say parties don't get along well enough, and so they're both bad, and they don't cooperate. But the judge seems to say, look, you need to be able to cooperate in making decisions for your child, right? And if, however, you can't cooperate, then what's the court going to do? Generally, what they do is they give one party the decision making. So this ties back into the parental responsibilities factors as well, which is why this case is here. So it's an interesting, I'm not going to read through them all. Some of the considerations, he cites his own case and says, here's some considerations I've implied in other cases in relation to decision-making authority. And then he cites a different case. They cite a case and they cite their own case and cite somebody else's case. So this is a nice sort of analysis if you ever need. This case that Mr. Justice Verhoeven did is a nice sort of new case that sort of walks through some of the best interests of the child factors, including the decision-making factors. So, it's too long to read. So the next case I found was called Dodging Horse and Lemus. And it's a decision of Mr. Justice Wilson. And it's about little 8-year-old Amelia, and she lives with her mom in Chase, and her dad lives in Texas. So where should Amelia live? Anyone? Not in Texas. No. So this was an interesting one around, again, the child's health and emotional well-being. The mom had said, look, Amelia is an Indigenous child, and she has status under the Indian Act. So she, therefore, has access here to health care, dental care, and other medically necessary benefits. And if she was in Texas, she wouldn't have that. So one for mom. There's also a factor that the dad canceled counseling for Amelia because he thought the counselor was affiliated with the mom too much. And the judge sort of chastised him and said, that really is not okay. So this factor, I think, went to mom. The child's views. There was a Hear the Child report done, and the judge noted that the child is very perceptive. The Hear the Child report writer, David Dundee, I don't know if you know him, he's a great lawyer in Kamloops. He was like, I couldn't keep up with her. She was just so animated and just talking away when he was doing the report. Anyway, the child had said that she wanted to live with her mom, but see her dad more, like dad go down to Texas in the summer and have dad come up in the spring break and visit, and didn't want to split Christmas and so forth. I thought this was funny. It wasn't under the Hear the Child. It was earlier in the evidence. When asked why Amelia wants to live with her mother, the father's answer is, because her mother beats her. And the judge is like, there's no evidence to support this serious allegation. So you can imagine what this guy is like if he would say that in court. He said a number of other things. Another factor, the child's need for stability. So we often think of that as being your home life, right? Do you have stable housing, right? Enough, food, the lights are on, you've got good people around you, like your partner is a good person, that kind of stability. That's what we think of. The factor that came into here was also about her attendance at school. She had missed a number of days from school, and the mother said it was due to a death in the family, her father's surgery, and her own surgery when she had a miscarriage and other illnesses. And the judge did flag it. He says, well, it's a bit concerning, but if you look at her report card, she's doing really well. She's doing well. So it wasn't a big factor, but it was something, okay, I'm just going to flag that. But that's an interesting factor to put under need for stability, is school. And it could be the same, you could say that if the child is missing a lot of extracurricular activities, right? If one parent isn't taking the child to their set extracurricular activities, that could be something you say, in the issue of stability, right? That it's not stable for the child, because children need their routines, and children need, their regularities, right? So again, that's something you could put into there. The ability to exercise responsibilities. So one of the issues was that the mom had some relatively recent criminal charges going on. She did something with a flower pot, like she kicked it over or something like that, and did some other things. And she also frustrated some of the father's parenting time. On the other hand, the father was unwilling to be flexible with the timing of his calls. So I think the father got that one. But just slightly, a bit. And then this one, it's good that the court in an additional factor, which was to acknowledge Amelia's Indigenous heritage. And the mom actually had 2 witnesses who gave evidence about the cultural activities in the Shuswap Nation, Shwapmek, and the efforts within the community to preserve their language. And Amelia got to learn her language at school. And the judge noted that it was important for Amelia to learn her culture and heritage and to be actively engaged with her Indigenous community while she was living in Chase. And the judge finally said, it's not simply aspirational as it relates to Amelia, but is already a fundamental part of her life. So acknowledge that connection to her Indigenous heritage and to her Indigenous community was fundamental, right? Now, you can probably guess where she winds up staying in Chase, and with the father having quite a fair bit of parenting time. But all those factors, anyway, I thought that was a really interesting case because it raised a number of factors that, well, I go, yeah, that makes total sense, but I've never seen sort of a judge, I don't know, oftentimes people may not make the arguments for the judge, but the judge may go, this fits here, and I want to put this here, and I can make this work. So my just tip to you is, with your client, is just every factor you can think of that goes to the best interest of the child, you can make it work, fit it in, make sure the judge knows about it, right? Maybe the mom didn't think talking about food was something you would talk about, like a diet, healthy nutrition and stuff like that. But the judge clearly said, yeah, the other judge said, yeah, let's talk about it. It's important, right? So, one part of, we always just read the 37.2 factors, right? And then how many do you get to the next subsection, which is 37.3, which is that an agreement or order is not in the best interest of a child unless it protects, to the greatest extent possible, the child's physical, psychological, and emotional safety, security, and well-being. And that's often a hammer you can use all the time. Or a feather, I don't know. I should be not so violent. But you can always bring it up, right? That this is, in the end, this is not in the best interest of the child because the psychological, physical, and emotional safety, security, and well-being isn't protected. So there's an interesting case that came out from Mr. Justice McIntosh this year called Forest and Forest, and it involved 3 children, a 17-year-old boy and 10-year-old twins. And an arbitrator had made a decision. The family was living in Saanich on the island, and the mom wanted to move to Toronto. And the boy, who was 17, wanted to stay in Saanich, and the mom wanted to have the girls live with her in Toronto. And the arbitrator denied the mom's application to move. But interestingly enough, in doing so, the arbitrator found unequivocally, that the twins' emotional well-being would be best served if they could be with their mother. And noted that even the Section 211 report writer had said that the twins would experience emotional harm and would require therapy in order to adjust to their mother's absence should she move without them. And yet, in order to keep the girls with the boy, and I'm sure there's other factors that, I'm sure the dad wasn't horrible in this case, the arbitrator denied the application to move. And so the twins were supposed to stay there and go into years of therapy. The mom appealed the arbitrator's decision, and the judge allowed the appeal and found that the decision, it was weird, like the judge particularly points to this, what the arbitrator found. He says, okay, this is contrary to 37.3, where you have to make sure that whatever orders are made are in compliance with the child's emotional, psychological, and physical security, stability, and well-being, right? And clearly not if even the arbitrator is like, hey, children are going to get messed up and need therapy, right? So the judge overturned the arbitrator's ruling, but then sent it back to the arbitrator, and which is often what even the courts of appeal send them back down. Sent it back to the arbitrator and said, okay, decide again, but know how I'm defining what this part of the law means, 37.3, so think about it when you do it. The difficulty for the mom is, by the time this all gets, I can't remember what date is, of course, the mom was trying to get the children into school, so they've already lost probably half a year. So that's a really interesting case to emphasize the importance of 37.3, because we often don't go to that.